What's your name? How do you say that? Thank you. What's his name? Huh? Oh, okay. I know his name, I was just wondering. If he was ashamed to give it. If he was ashamed of who he is or any of that. He has no shame. No ethics. You have no ethics either, do you? Are you about to dismiss this?
No.
Okay, then set the court date and I'm leaving.
Set a trial date?
Yep.
What's the trial date?
I want to be heard on a few matters.
You guys can talk amongst yourself when I'm gone. Because if you start the hearsay bullshit again, you're a tainted jury. So if he says anything other than anything about the case, you just tainted the jury. Because if the jury was sitting here, he wouldn't be able to talk hearsay.
You don't get a jury trial.
I don't what?
You don't get a jury trial.
You're the jury. You're supposed to be an impartial judge, which means an impartial jury. If you let this man spout off about anything other than the facts of the case, you just tainted the jury, you. You'll be recused like the last 4 judges. You'll have a commission of judicial conduct complaint. You'll have a lawsuit. You can laugh and joke all we want. This is an unethical piece of shit prosecutor.
Stop. Threatening to sue a judge and I threaten to throw fish in the water. So
I'm not threatening fucking shit. I'm threatening to file a formal complaint on you because you're a piece of shit.
Fine, sir.
You're a fucking scam-ass judge over creating fucking bullshit. Moron, if you fucking don't give me their name and their information as required under by law, right? So, Rule 15.1b, the state has 30 days from request. I put in a motion to compel fucking law 4 fucking months ago. They had 30 days from that motion to give me their 15.1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. You already know what fucking time it is.
One of them is the victim.
Who's the victim? Darrow's your fucking boss. Deloria's a dumbass. Where the fuck is the arresting officer? Why is this bitch here not the fucking arresting officer?
Sir, calm your language.
Why couldn't I bring the fucking witnesses?
Sir, please.
Where's my witnesses?
This is a pretrial conference.
Then why the fuck are there witnesses
They're
here?
allowed to be.
They're not.
Yes, they are.
No, they're not. Read the fucking rules, bro.
Are they the victim?
They're not the fucking victim, and if he pulls that shit, you're getting recused too.
Sit down. Are they the victim?
No.
I'm asking.
I got the fucking police report right here.
Are they the victim?
If you fucking lie, you already know what fucking time it is.
One of them is the victim.
Who's the victim? Neither one of them is a fucking victim. A victim of her own fucking stupidity, maybe. She's a sir. Judge Riojas, that woman is listed in the police report as a witness, okay? This piece of shit hasn't turned over his fucking witness list and it's been 105 days. Where's the Rule 15 witness list? How the fuck are we gonna have trial if I haven't even received the witness list yet? Huh, Rojas? We have fucking 30, 40 fucking days to have the trial, and I haven't even received... What? He's gonna call her as a witness? Why hasn't he disclosed that under Rule 15.2b, 1.1b? Where's my fucking witness list? Where's the state's disclosure? It was due fucking July 11th. Then Crenshaw said August 9th. Then Mayhew lost her fucking mind and didn't enforce it. Anything that this motherfucker didn't file by August 9th is not valid at trial. So if he didn't turn over a witness list by August 9th, there's no witnesses. And if you try to enforce some kangaroo bullshit, you'll be right up there with Crenshaw and Mayhew, right where the fuck they went. Time out.
Done?
There's nothing more to say. Set the trial date so I can leave, so I can quit disrupting your court.
Sit down.
You let this motherfucker get off some bullshit, it's gonna be on you.
Fine. You had a statement. You said pretrial matters.
I'm sorry, Your Honor. What'd you say?
You said you had some matters to discuss.
Yeah, just wanted a few things to bring up, Your Honor. Obviously, the court's familiar with Mr. Martin's conduct. I don't need to get into it.
I'm not familiar.
So you see how he just...
You guys hear Matt there? Holy shit, let's rewind and listen to Matt. Where'd I go? Let's rewind and listen to Matt for a second. Hey, everyone. There's an email and a phone number right there. I'm seeing a couple new names. That means you haven't likely sent an email yet. Please do me a favor and send an email. Isn't that right, Michael? Send an email. Make a phone call. Please be respectful. There's a There's a motion in the description, the anti-slap motion. Give it a read. Or if you don't want to read 43 pages, that's okay too. But there's a lot of good stuff in there that pertains to First Amendment liberties and exercise of First Amendment liberties. But tonight's about Matt.
Yeah, just wanted a few. I'm sorry, what'd you say?
You said you had some matters to discuss.
Yeah, just wanted a few things to bring up, Your Honor. Obviously, the court's familiar with Mr. Meyer's conduct.
Well, how on earth would that be, Matt? How are they familiar with the conduct? Did you brief them prior? You corrupt prosecutor?
So I can quit disrupting your court. You let this motherfucker get off some bullshit, it's gonna be on you.
Fine. You had a statement, you said pretrial matters?
I'm sorry, Your Honor, what'd you say?
You said you had some matters to discuss.
Yeah, just wanted a few things to bring up, Your Honor. Obviously, the court's familiar with Mr. Meyer's conduct. I don't need to get into it.
I'm not familiar.
So you see how he just fucking tainted you? Objection, stricken from the record. He just...
Riojas isn't familiar. What the hell's going on? Riojas isn't familiar with it, is he?
See how he just fucking tainted you?
Just wanted a few things to bring up, Your Honor. Obviously, the court's familiar with Mr. Meyer's conduct. I don't need to get into it.
First time I've met him, so I'm sorry. Riojas, keeping it real. What's going on, chat? Please, if you haven't sent an email out, keep it respectful. I know that you don't want to be respectful. You know, I know that you see a guy sitting in jail for free exercise of rights and you're enraged, right? You can barely put words to what you're experiencing as somebody sits in jail for YouTube videos. Especially when I sit here, I'm making YouTube videos, so, you know, think about that. So please, keep it respectful, even though I understand, right? I understand, but I read some just great emails the last few days from people that have attached me to their emails. I really appreciate you guys forwarding those on to me. Well thought out, well written emails. I haven't gotten any of the threats, so it's nice to know that my audience isn't threatening people. But I think you know, who knows? Maybe the judge will never read it. You know, maybe it's just what it is, right? But you know, one would like to think that you would, you know, think about the input from the public, right? So, what's going on, chat? Jenny, Stephanie, Michael. Guys, I was on Michael Lawrence Accountabilities and the dreaded Rabble Rousers show earlier tonight. I had a great time. Everybody said I looked tired, but I still had a great time. So, but welcome into this chat over here, Edward, Sylvia, I appreciate you so much. I don't think that I could adequately convey how much I appreciate Sylvia to the chat, or even the audience at large. Sylvia, I appreciate you so much. Howard, what is going on? Joe, Dolores, News Now Victoria, 7 Cities, Chad Crum, Mark Wunderlich, Sassy. What's going on, Sassy? I'm sure I missed some people. Bob, DJ Bob, Kevin, Disabled Outcast. What up? Early and often. we're getting into this. This is Matt Walker. This is the day that Matt Walker was castrated by Elaine Myers. This was the day that it all ended for Matt Walker, where all of his lies and all of his corruptions ran into the one person that knew every single rule better than he did, and a judge that finally allowed the defendant to be heard on the matter. And what ensues over the next 28 minutes, I gotta shut the fuck up. Over the next hour and 28 minutes is one of the most glorious things that I've ever listened to in my life. I'm so sad there's not video with this, because can you imagine the look on Matt's face when he gets humiliated like this for an hour and a half?
So you see how he just fucking tainted you? Objection, stricken from the record. He just attempted. What does that got to do with the case? What does my conduct in the court got to do with the facts and fucking findings of the legal figure? Like, did I commit the crime or not? Has no fucking clue has no relation if I come in here and talk shit. So why the fuck did he just, the state's first statement was, let me prejudice you, Your Honor, by some bullshit that's not even admissible at the trial. What I fucking said in Mayhew's courtroom has nothing to do with the fucking did I commit the crime or not.
Nico and Sai sent me a killer email. I think, you know, what we're gonna do for an upcoming video is, you know, I don't want to put people's I'm not gonna put people on blast, like, and say, oh, and this one's written by whoever or whoever, unless somebody reached out and said, you know what, you can attach my name to it. But I think we're gonna read some of these letters too. I think that would be a productive use of our time as well. So, you know, just so that the Walkers, really, it's the Walkers that need to gain an understanding of what they're doing. I know they're pure evil. But there's always, you know, don't you always hope? I mean, what else do you do? I mean, chat, what's the answer? I mean, what's the answer if you can't hope?
So why the fuck did he just say that? The first thing, the state's been dealing with this case for 100 fucking days. I don't have a witness list. They haven't disclosed jack shit. I've sent this piece of shit at least 50 fucking emails. And I'm telling you on the record right now, if he doesn't turn the witness list over by the end of this hearing, I'm gonna sit in his fucking office every fucking day in front of the window until he gives it to me. You understand? 100 fucking days, I haven't even got the witness list. It was due July 11th at the first pretrial. I had a September 30th trial date. Where's the fucking rule? To vacate a trial without either party moving, the judge needs to show me something signed by the Arizona Supreme Court Justice saying you're suspending Rule 8. Who the fuck suspended Rule 8? I didn't move to suspend Rule 8. He didn't move to suspend Rule 8. You didn't grant the suspension of Rule 8 because that requires a Arizona Supreme Court Justice. How did we get to the point where my trial was vacated and I didn't move to vacate it? He didn't move to vacate it. So why the fuck is it vacated? State law says you cannot vacate a fucking trial unless it's signed by the Supreme Court fucking justice. So what are we doing here, Rojas? This is the 5th fucking courtroom I've been in with this kangaroo bullshit where fucking the law just seems to, we got the hearsay, not admissible unless you're gonna let rebuttal evidence. Just now, talking about anything that's not related to the facts and findings of my guilt is hearsay. We could, it's, I get what you're saying. Okay, I respect that. It's not, it's gossip. It's fucking irrelevant. Thank you. It's fucking irrelevant. In every courtroom I've been in since this case started, he started his fucking petty bullshit. And his wife's a fucking professor at the school too, right? And this piece of shit got my wife fired from her fucking job, okay? And I can guarantee you, this shit's gonna become way fucking bigger than this court case under your watch. Now let's read the fucking rules about vacating a trial, sir. You can't just vacate a trial without, right here, Rule 8.5. A party may ask to continue a trial, right? By stating the specific reasons for the request. A court may continue a trial only on a showing that extraordinary circumstances exist and that delay is indispensable to the interest of justice and only for so long as necessary to serve the interest of justice. The court must consider the rights of the defendants to a speedy disposition of the case. The court must state specific reasons for continuing trial. Not just put a thing that says your trial's vacated, it's continued, that's not a specific reason. And when I fucking object to it, and she says, oh, you can't put the word bullshit in your order, so I'm objecting to it, or I'm striking it from the record. So my objection to my trial being vacated didn't get put on, didn't get, whatever you want to, litigated motion between us because she struck it from the record because my motion had the word bullshit. I've said fuck 50 times already today. Why did my motion get struck for bullshit? That's why she was my judge for 3 days. This piece of shit stands at the fucking thing.
Sir.
All right, I'll stop. All right. I'll talk to you. So this unethical prosecutor stood in Judge Mayhew's courtroom after I got kicked out and literally talked into this microphone and said, Your Honor, I'd like to be heard for the record.
Unethical prosecutor Matt Walker. That's what he is. Lane just laid out the rules why the case should have been dismissed right then. Matt Walker. Here's ethical prosecutor Matt Walker. The disclosure rule, this is called disclosure, and it's discontents. The disclosure rules have been described as a shield, not a sword. Despite that, practitioners sometimes attempt to use them as a sword in order to achieve their desired outcomes in criminal matters. This presentation seeks to pull back the veil both on requirements and best practices under the rule and leave everyone a bit more prepared in the event they are used as a sword against you. What do you guys think? What do you guys think what do you think that's all about? Continuing education from the prosecutor. What does Matt do with the disclosure? Is he ethical with the disclosure? Just wondering. Is he? What up, Mr. Denicola? Mr. John Denicola, Joe Coe? What up? Somebody said that fuck Lane or whatever because he's a Trump supporter. It's just ironic, bro. It's just ironic. It's a hat. The guy doesn't even vote. So it's because everybody in Tucson is dark blue. It's high level trolling. I don't know if you haven't watched any of Lane's stuff or not, but that's what that's about. So what do you guys think about that? Does anybody think that Matt Walker's ethical? Let's get a 1 in the chat for ethical Matt Walker. Let's get a 2 in the chat for unethical, manipulative. Let's see here. Matt Walker, principal, assistant prosecuting, city attorney. Matt Walker is a prosecutor with the city of Tucson. When he's not responding to motions, he can be found yelling no at the top of his lungs while watching University of Arizona sports. Mr. Walker lives in Tucson with his wife Shannon, their 2 children, and 2 bad dogs. Even if my dogs were bad, which they're not, they're great. They're great dogs. I wouldn't say that online. when he's not responding to motions, I've said this one before, but just read that sentence. When he's not responding to motions, and what did Lane just accuse him of? I think it was not responding to motions.
We're getting the times, dates and times available for our witnesses. We'll let you know when you have trial. So how the fuck does he know his name?
Bunch of twos in there.
I haven't even received it. I'm the fucking defendant, and it's been 100 days. So he's telling the court, I have my list of witnesses, and I'm saying, yeah, it was due 3 fucking months ago. So how does he have his list of witnesses? He's telling the court he has his list of witnesses, but the defendant doesn't have the list of witnesses. How can I prepare my trial? How can I interview this moron if you fucking don't give me their name and their information as required under by law, right? So Rule 15.1b, the state has 30 days from request. I put in a motion to compel fucking law 4 fucking months ago. They had 30 days from that motion to give me their 15.1 disclosure, witness list, all that shit. Or by the first pretrial. That's the law, sir. You follow the law. The law said first pretrial, you must receive. I've turned over all my disclosure. They've had all my Rule 15 disclosure, all my witnesses, all my evidence, everything for 4 fucking months. I don't even have the witness list. But they're openly admitting on record that they've been interviewing witnesses, talking to witnesses to get their time available for trial. They're clearly communicating, but I don't have a witness list. How can I prepare? How do I know who's going to be called against me? Due fucking process. And I'm telling you right now, I got a federal lawsuit in a different county about judges that let this kangaroo bullshit done. And I'm telling you, you can read my lips. He will be under 2-year buyer suspension. Play games, and it's going to be you caught in the middle, sir. And it's not, and I'm not, this is how I got to talk, because this is my 5th fucking court date where nothing's happened by the law. So either today it's going to go by the law and you're going to dismiss this shit under Rule 8 and Rule 15 because my right, with prejudice, speedy trial rights, they have nothing. So how are we going to have a trial if they have no admissible evidence because they didn't turn it over by August 9th?
First of all, sir, I can't dismiss the case once you filed the motion.
I have, and they fucking threw it out for the word bullshit. That's fucking bullshit itself.
Have a seat, please.
Don't tell me you can't hear my motion to dismiss because it contains the word bullshit.
I didn't say that.
No, she did, and that's why we already had this hearing a couple weeks ago where I should have got my motion to dismiss granted based on everything I just told you, but instead she ended the hearing and let this man go in there and straight on this fucking microphone say, yeah, Your Honor, the state just wants to know, we're figuring out our witnesses, and when we get it to you, we'll let them know, right? It's literally on the minute entry, okay? So where the fuck is it? And then I sent him 7 emails since that hearing, unreturned. Where's the witness? I call the fucking prosecutor every day. Where's the witness list? Where's the witness? Sir, how can you proceed over due process if I don't even have the procedural due process, right? Pre-deprivation, post-deprivation rights, right? So I have the opportunity to confront the witnesses before me, opportunity to be heard in an impartial trial, right? Okay, well, anything from impartial so far. When Cranshaw said, your deadline to turn in, the thing I'm arguing about right now, Cranshaw said he had till August 9th to turn that in. It's literally in your fucking minute entry that the state has till August 9th for disclosure. Well, we're here at fucking the end of September. Nothing. Not a fucking thing. It's literally in the minute entry from my July 11th pretrial when they set my September 30th trial. Why did Cranshaw, sir, if there's a conflict of interest, you declare that before the case, okay? Up until they got my wife fired, she was a law clerk for a federal judge across the street, right? They didn't even get her fired. She resigned, but you get what I'm saying. So the idea is you follow the law, okay? I know you work for the city. He works for the city. I'm not accusing you of that because I've only met you for 10 minutes. But I'm telling you what's been going on is how would you let a case move through arraignment, pretrial, set a trial, and then be like, oh, it's a conflict of interest, vacating the trial. Why the fuck didn't you declare it a conflict of interest before we started proceeding in the case? That's bad business. So they threw it to Mayhew, and then she wouldn't let me talk. She let this man stand in there and lie right into the fucking microphone. It's all over my YouTube. The whole world has seen this piece of shit. Sorry. This unethical prosecutor fucking do everything he's doing, and we know why he's doing it, because I'm suing the cop that did it, and that's her little buddy. She's an undercover informant for the Tucson police,
Your Honor,
and her
I
mommy
want
fucks
Mr.
the
Myers
cops.
to stop making a record directing anything to the victim, calling the victim
Witness.
names.
You bring the witness. You get. Hey.
Sir,
All right. Okay. Go ahead.
She's the victim.
Okay. But he's that okay. If he's okay, he's saying she's the victim. He just lied to you right to your face, sir. I can show you the police report where it says Mackenzie O'Brien, witness. So twisting this shit where she's the fucking victim is their only hope, because then they won't give me a pre-trial interview, because they're saying, and this is why Crenshaw got off the case, because we came in the thing, he said she's a victim. She's not. It's literally, sir, you have the police report, fucking read it.
I don't have it.
Well, then how do you not have it when I've turned it in my motions? That's what I'm saying, sir. You don't have the police report? Then how are we standing here letting him call her a victim when the police report that I was given by the prosecutor lists her as a witness?
He's allowed to claim whoever someone's a victim.
Oh, okay. Well, I'm a victim now. Well, okay. So let me say this, sir. So you're gonna. I'll allow you to say.
Bev, the reason why it's beyond you, the reason why him not being held in contempt is beyond you, is because there's a process for that in Arizona. You just can't hold somebody in contempt in Arizona. It's not as easy as that. There's a trial, so Lane can call witnesses. So, there's not really an incentive to do that. So, yeah, that's uncomfortable. And how do you walked out of what hearing thinking he won? He walked out of this hearing thinking he won? Yeah, he definitely walked out of this hearing thinking he won. And I know this one's new to Bev, but what happened? Chat, tell Bev what happened. Other than Matt Walker went psycho. That's what happened. Files a Rule 11 and then is too cowardly to even argue it himself, withdraws from the case, and goes and gets his Vagisil.
Say that he has the burden's on him to argue all that, right? Okay, so now the burden's on me to show you something. This victim right here, so this incident took place May 20th, okay? On July 30th, she was posting on her own YouTube channel talking about the case. So how can the victim talk about the case, but I can't talk to her, right? I'm not allowed to contact her, but she's allowed to go on her YouTube and say, Lane's lying, it looks really bad. I know you got videos of me lying, but I promise you I have a video that shows Lane. Sir.
At a trial, when there's a trial, you have the right to present that evidence.
There's not going to be a trial because you're about to dismiss this.
No, I'm not.
Okay, then you're going to recuse yourself.
I'm not going to. Why would I accuse myself? Why?
I'll file the motion. Don't worry.
All right, now.
You'll see.
State wishes to make a statement.
Yeah, my turn, Your Honor. First thing the state's going to ask for is a motion to modify the conditions of release. All these requests are going to be directly stemming from the case. They're not going to impact Mr. Myers' ability to defend the case in any way. Mr. Myers has taken the information the state has provided under Rule 15 and posted on the internet. That's a violation of Rule 15.4.
Oh, sir, objection. We're not fucking having.
Sir, he didn't interrupt you. You don't interrupt him.
You better fucking hold the law.
Sit down.
A violation's a
Sit down.
violation.
I said sit down. You'll have a chance.
He don't get to stand over there and cry victim. He's the fucking state of Arizona and the burden of proof's on him.
Right.
Give me the fucking witness list. You want to sit over there and talk shit about what I violated? Guess what? I didn't post shit until he violated the August 9th rule. So if you don't follow the rules, you don't get to enforce them.
Sir, you're toying dangerously.
I get it. I feel you, sir. I feel you, sir. It's nothing personal. It's nothing personal. It's nothing personal. It's nothing personal. It's fucking business, man. It's business. This is my fourth judge. This is 106 days. 106 days into the case. You only have 180.
Included time. When you file a motion to continue,
I did not file. This is the bullshit, sir. There's no fucking motion filed by me to continue, and that's the bullshit Crenshaw tried to pull. The last judge tried to pull. I did not file a fucking motion to continue anything. I filed one before my 11th pretrial. I then withdrew that motion. It was ruled on, withdrew. I showed up at the fucking hearing. Cranshaw wrote that shit on there. I filed a motion showing that wasn't true. They didn't fucking hear it because it said bullshit. You better not, sir. You better not come in here and state into that fucking microphone that I filed something to continue my trial. That will be the misconduct commission complaint that you can't fucking read. I did not continue shit. Pull the fucking motion out where I asked to continue my trial. Every fucking day in this case is included. Don't pull that bullshit. I don't give a fuck what you got to say. Look at the record. Read the fucking thing. It says that I filed a motion. Show me the fucking motion where I continued my trial. Show me it. Pull it out. It's in the file. Pull it out. Walker, pull it out, bro. Pull it out. Pull out the fucking motion that I filed to continue the trial. But that's what I'm saying, sir. You don't get to make the law up. You get to follow it. I just read you why you're breaking the law, and you looked me dead in the face. And
Mr. Walker speak, and you'll have your chance.
he's not allowed to sit here and talk bullshit. Everything I've said it might be loud, it might be obnoxious, but it's legally based. He's trying to bias the jury. You just sat here and looked me dead in the face, sir, and said that time included. Oh, you obviously haven't done your research on this case. Clearly haven't read the record. You're just going off the fucking surface level bullshit. You saw something in there. Just because Cranshaw claims I filed a continuance to cover his ass, that doesn't mean I filed the continuance. Walker didn't file a continuance. Neither one of us moved to continue the trial date. I have emails from him stating he doesn't know why it was granted. He didn't move to continue. He agrees with me. It should not be continued. So I could show you an email from the state saying he wanted this.
So we can just move on. I agree that Mr. Myers has never filed a motion to continue. So can we just move on past this?
So we could just move on past the fact that the law says if no motion to continue is filed, you have to dismiss with prejudice, because unless you do it with if neither one of us moves, the only way you could do it is something signed by the Arizona Supreme Court Chief Justice saying you're suspending Rule 8. Right. Neither one of us said this. You just said time included. There's no suspension of Rule 8 here. Every fucking day, second time since I've been falsely arrested is counted in this case. Where's the fucking arresting officer? Sir, so right now you need to tell him he needs to produce the officer for an interview. They won't fucking give me the officer that arrested me on the side of the road, put me in the cop car for an hour and a half. They will not make him available for a pretrial interview. We know he's not the victim, other than a victim of his own stupidity for arresting me and getting himself into this. Where's the fucking witness? So 105 days in, they won't give me the witness list. They won't produce the arresting officer. They're lying to you about the case being continued. You don't have time to have a fair trial. We're at day 106. You have till day 180. That's tactical advantages. I've read all the Supreme Court case law. They're doing this to gain a tactical advantage that gives you the power to dismiss it with prejudice. I can show you the fucking case law just like I did in my motion. See, I'm arguing from the Supreme Court. He's arguing from his feelings. The Supreme Court of Arizona, sir, is ultimately going to be the arbiter of your decisions. And that's what I'm telling you. You better think twice before you violate Lane Myers. And that's not a threat, sir. I'm going to apply the law to you just like you. So this case is, I'm charged with 2 counts or whatever for her lying bullshit. Well, he thinks that I'm being prosecuted for whatever this charge is. And I'm standing here saying, all I see on this ticket is, and the judge's career, and the prosecutor's career, and the officer's career. So there's a conflict of interest with all of us right now. Because it's not even a conflict of interest, though. It's a conflict of intent. The intent by this prosecutor is to get off some charges to prevent the officer being sued from unlawfully arresting me. Otherwise, why wouldn't he make the officer available? Why haven't I been able to question my accuser? Why did the man that held me in handcuffs...
And why are these ones happening? So that bullshit prosecution was going on to try to delay the lawsuit moving forward, which he's clearly going to win now. And why was all this stuff filed? Was it because he actually did these things? Did he do these things? Eight felonies, 6 misdemeanors. Did that happen? Did he do that? Or is it the same thing? The Walkers are trying to prevent him from moving forward with the dismissal of the injunction, and therefore certainly making it more difficult to sue them in their personal capacities for this lunacy that's happening right now.
And the most disturbing part is, while being in handcuffs on the side of the road for an hour and a half, the cop looked me dead in the fucking face, and you're going to see this on his body cam, and he said, a jury's just 12 people too stupid to get out of jury duty. And you're right, the judge might dismiss this case, but you got to deal with me fucking with you tonight. This fucking cop said that on the body cam, for the whole world to see, and he's worried about me releasing it because it looks fucking bad, because before he came and arrested me, Your Honor, he put this woman in handcuffs because she asked him to. The victim was playing BDSM in the parking lot with the cop saying, sir, he walked up, I feel you, I won't use that, I got it. Hey, no, he let her handcuff her, she got the, look at the, she got
It's my
the
turn,
the police
Your Honor.
laptop.
Okay, let's see how your turn works out.
Watch the video. I'm not taking it down either. The whole world needs to see what happened to this. The whole world needs to see what happened. She asked the cop to arrest her. They sat there for 45 minutes. The cop said he could beat her. No, dude, there's no trial. You're about to dismiss this case. Okay, well, there won't be no trial with you then.
My turn, Your Honor. Yeah.
To lie.
Back to what I was saying. Under 15.4D, none of this material is supposed to be disseminated.
He's talking about the police report and the body cam. See how he's saying material? Police reports and body cam. Police reports and body cam. Police reports. Thank you. Thank you. Thank you.
Go on.
Material that's provided under Rule 15, like the body worn.
Bev, have you lost your mind? How on earth is me playing a court hearing contacting anybody? I'm making a video about this court hearing. See, this is the kind of dumb that you can't, like, what do you do for this? I mean, what do you do? Yeah, I'm sure I'm not going to get Lane in more trouble. I'm sure, yeah, I'm sure. Moron.
And the police reports is not to be made public. So on that basis, Mr. Myers has violated Rule 15. The videos need to be removed from YouTube, number one.
They're not coming down.
Number two,
Ever.
if they don't come down, the state is going to ask the court that you hold him in contempt.
And I'll do it. Pay, how much do I owe? The videos are not coming down, sir, ever.
Second thing is, no
It's my First Amendment right. And no, hold on. Objection. I know. Let me peacefully. All right. Let me peacefully. I have an objection to what he just said. Let me peacefully make my objection, sir.
Please, can we move on?
No. He just said that. Hold on. Time out. No, sir. I have the opportunity to be heard.
You did when he's done.
No.
When he's done.
Directly to what he just said.
He's done.
I'm objecting what he just said. I want to put an objection on the record to the first thing he just said. He said that I was releasing body cams and body worn camera and police reports that they provided. That's wrong. I got it from a public record request from Chris Avey, city attorney. So anything I get from a public record request, I can put on my YouTube channel. Now it might be the same material that's in their disclosure, but we could go to court. Charge me with contempt. I'll show you.
Bev, in what universe? In what universe do you think I can't talk about something that is a matter of great public interest? What do you guys... Alright, I can't do it tonight. I'm trying to have a lighthearted evening. Bev, you can come back tomorrow. You're in timeout. You've completely lost it. That's right. That's right, Aaron. Mm-hmm. Yep.
The public record request. You can see a video on my YouTube of me giving the public record request to Chris Avey, and Chris Avey going, here, take a picture of me. Chris Avey stands on my thing and goes, look, I got your public record request. So he's lying again. He's lying. He just said I should be held in contempt for releasing a public record received under a public records request. He's lying. He's attempting to manipulate because I sound crazy and all that. He's trying to be the voice of reason. He's the voice of lies.
Okay, down.
He's trying to be the voice of reason. He's the voice of lies.
Okay, down. Continue.
Voice of reason. He's the voice of lies.
Okay, down. Continue.
Number one.
He gets to tell you what you need to do.
Go on. He's asking. You tell me. He's asking.
I'm requesting to modify Mr. Myers' conditions of release accordingly. Number two, Mr. Myers needs to be directed not to have any direct contact with judges, court staff, city prosecutor staff, or other city employees. If he wants to do something on a case, he can file a motion through the appropriate
He just
channels.
asked you, objection,
Sit down, sit down.
objection, public officials. I can contact public officials at any time. Every person he just said is a public employee. You will not take away my rights.
Sit down, please. Continue.
Every person he said, though, was public record, public official.
Go on.
And these are people that Mr. Myers has been harassing and calling cunts, among other things, Your Honor. which-
Objection, irrelevant, man. What the fuck does that got to do with what I did on May 20th? Who I called a cunt? He's tainted. That's irrelevant. You're allowing him to prejudice the jury, sir. You're supposed to be impartial. That means that if the jury was sitting here, you wouldn't allow him to say that I called a public employee a cunt. That has nothing to do with this case. So you have to act the same as if the jury was sitting there, sir. That's how you have to be at all times, an impartial
Let me ask you this-
jury.
Let me ask you this question. How do I know what he's gonna say till he says it?
Who? Ahead of time. Ahead of time.
How would I know ahead of time?
Ahead of time what he's going to say.
How would I know ahead of time he's gonna say what he's gonna say?
But now that he said it, why didn't you say that's irrelevant? Why didn't you say that has nothing to do with his guilt or innocence on May 20th?
Had nothing to do with-
Then why the fuck? That's the third case courtroom I've been in where he talked about me calling him cunts. Hey, cunt is free speech. Whatever. So
But it's not polite speech.
I don't care if it's polite.
In this courtroom, you be acting.
I understand. Don't call nobody in here. But I'm saying, he's saying that in my communications with public officials, I've called them that, right? That word, right? That's my right, okay? And it has nothing to do with whether I'm guilty or innocent with what happened at O'Reilly Auto Parts on May 20th.
I agree.
So why is he, do you understand? Why is he talking about it?
Quiet, quiet, let him finish. Go on.
Your Honor, the court can impose, modify conditions of release for the protection of anyone in the community, and of course, have wide discretion to do that. It is not onerous to ask Mr. Myers not to call court staff or not public officials.
Take away my rights is onerous.
A cunt. Number three.
You're a cunt, bro. Your wife's a cunt.
Sir.
Your Honor, I'd ask Mr. Myers to be held in contempt.
I'll pay the fine. You're a cunt. Your wife's a cunt. How much is the fine?
I'll poke you.
Well, you think jail? So now you definitely are removed from the case because you just threatened me with jail, just like Cranshaw did. And look what happened when Cranshaw threatened to throw me in jail.
Number three.
Put me in jail for saying it. I dare you.
The state will respond to any substantive motion filed that is not stricken by the court.
How can my motion be suspended? Here's my motion. Permission to approach. Here's my motion. Permission to approach, sir.
Yeah, please finish your.
Let him finish. If you have a chance to say, please stop. Go on.
No contact with non-court prosecutor, people who are not related to this case, such as immediate family.
His wife's a public official. His wife is a public employee. Don't let him gaslight us.
Like the voicemail Mr. Myers left for my wife saying he.
Yeah, and I'm gonna keep sending her fucking emails and calling her because she's a public official.
And the email that he sent to me saying he was gonna come pay my wife.
So I wonder, did Riojas change the conditions of release today? This day? That's what, let's listen to what Matt's asking for again. This is what this is about, right? This is what this whole thing's about right now, right?
His wife is a public officer.
Yeah, please finish your.
Let him finish. If you have a chance to say, please stop. Go on.
No contact with non-court prosecutor, people who are not related to this case, such as immediate family.
His wife's a public official. His wife is a public employee. Don't let him gaslight us.
Like the voicemail Mr. Myers left for my wife saying he.
Yeah, and I'm gonna keep sending her fucking emails and calling her because she's a public official.
And the email that he sent to me saying he was gonna come pay my wife a visit and then come.
Now he's lying. Here, sir, I'm gonna show you permission to approach. I got the email right here. I said I'm gonna go knock on his neighbors' doors and ask him if they want to vote for Trump. That's what I said. So he's twisting the narrative. He's a squeamy little bitch. I'm telling you, man. I'm telling you, dude, you're letting this fucking prosecutor embarrass the entire profession. You and this prosecutor are embarrassing the entire legal profession right now. Unless you're about to dismiss this for all his fucking games. He can't make a serious argument. Oh, the police said this. This is what happened. Nothing. It's, oh, he called him a cunt. Oh, he emailed my wife, who's a public official. Oh, he said he's going to come put a billboard sign for Trump next to my neighbor. You know, I didn't say I'm coming to his house. I said I'm gonna go to his neighbor's house. It's fucking public record. He's a public official. It's public record. You can type Matt Walker in Google. You'll know exactly where he lives. He's a public official. He has a less expectation of privacy than a private citizen. I've checked all the laws for residential picketing. I'm not breaking the law, so why is he bringing it up? I'm hurting his feelings. Fuck his wife. She's a cunt. She's a public official. Whatever. I can talk to public officials as long as I don't threaten them. I can go. I went and stood in front of Laura Conover's house. She didn't tell the fucking judge, oh, he came in front of my house. He called me a cunt. I call Laura Conover a cunt every day.
Let me ask you a question. How is that Laura Conover any less relevant, any more relevant?
No, I'm saying as an example of standing in.
Once again, you're delving into the.
Oh, that's because they sent the case from here. What are you talking? Time out, sir. You don't know what's going on here? I had 2 cases here.
There's 2 here and there's 1 in Justice Court.
Yeah, because Crenshaw declared a conflict of interest after we set trial. So what I'm saying is in that case that got transferred, it's now over there, right? Laura Conover's department, you know what I'm saying? They're not complaining about me going and everything I've said to him.
Once again, it's not relevant to this case.
Okay, so then neither is what he's saying.
Let's go on.
Now I know ain't no mate. Why can't you just stand on business, bro? You've been here 20 some years, dude. I know we both know whose interests you're protecting, but I'm not accusing you of impropriety yet. But if you just told me I would go to jail for saying protected speech, yeah, you could say it. But you actually have to have a trial for contempt. And you can't issue contempt in the same hearing that the contempt takes. So, like, you just literally threatened to put me in jail, knowing that you can't even do nothing about my contempt. You have to issue an order to show cause for contempt. So how the fuck are you...
So that's the problem with Bev, right? Like, even me, I couldn't articulate the rule there. I knew that Bev was wrong, right? But Lane knows exactly why the judge isn't going to hold him in contempt. Let's listen why the judge is not going to hold him in contempt.
Speech, yeah, you could say it, but you actually have to have a trial for contempt. And you can't issue contempt in the same hearing that the contempt takes. So, like, you just literally threatened to put me in jail, knowing that you can't even do nothing about my contempt. You have to issue an order to show cause for contempt. So how the fuck are you going to put me, you know what I'm saying? So you just attempted to manipulate your power against me by saying, I'll lock you up. You can't, you can show, or now you can issue an order to show cause, sure. And then we can have a hearing about my contempt. And then if I'm found to be in contempt, if it's criminal contempt and you want to try fine over $300, criminal contempt doesn't carry jail. It's a civil infraction. It's not a crime. You can't be taken to jail for contempt. You can be detained while a show cause order is issued. You are not going to weaponize the court either, sir. He's not gonna, and you're not gonna.
They did that day.
Sure, Your Honor. These conditions that the state is requesting have absolutely no bearing on Mr. Meyer's ability to defend the case. They have no bearing on his ability to do anything. The state would like nothing more than to simply proceed.
Listen, Aaron, you're not wrong. You know what I'm saying? And sacred knowledge. Exactly right. You know what I mean?
This case without Mr.
Then why don't they give me the fucking witness list? It's 105 days. They want to proceed with the case? Give me the fucking witness list. Give me the arresting officer. You can't proceed with the case? They're sitting here saying, oh, he put the videos up. You heard our feelings. You said you were going to protest in front of my house. My legal right. You're going to exercise your legal...
Do I think Lane didn't know something? No, I don't think Lane didn't know. Lane knew he was going to jail the other day. Lane's been pretty perceptive with things. Certainly things that he's told me, so.
Legal rights while we violate your rights and hold the witness list and hold all this. He wants to modify the conditions so I can't contact public officials. Oh, he's got the public records up on there, but he hasn't turned over anything. Every single...
I still don't think they're going to win, though. You know what I mean? Him being in jail right now isn't a win. I mean, to them, it's a win, right? To them, it's a win, but you know, unfortunately, they're short-sighted and dim-witted. So, yeah.
Fucking piece of disclosure under Rule 15 that I'm required to give, I've given. They've given none. None. None.
You can file a motion.
I did file fucking 10 motions and she lost her shit just like you're doing it, bro. I'm telling you, I can see.
Made all disclosure available. So, the
Next
next
time, objection. So you made your witness list.
Mr. Myers, sit down.
Tell him to
Sit down.
st-
You'll have a chance to-
Tell him to state for the
You'll have a
record.
chance to respond when
Where's
he's
the
done.
witness list?
You'll have a chance to respond when
If
he's
he's
done.
made the witness,
Sir, you'll have a chance to respond when he's done. Okay? I'm not preventing you to speak, just have, kind of be orderly. Okay.
As far as the interviews of the officers, Your Honor, the state was prepared to set those until Mr. Minor's conduct made that impractical. The state thinks that what would probably be best is if we simply have an evidentiary hearing where we can do this under oath in a court. Mr. Myers can essentially take their testimony, it'll be sworn testimony, which is probably more effective anyway than simply attempting to facilitate an interview. So we can set an evidentiary hearing for some point in the near future.
we got 50 days till
We can set a trial.
180.
But the state is requesting that Mr. Myers' release conditions be modified.
Well, in terms of him contacting, we can't contact the victim, clearly.
And I haven't.
Actually, he has, Your Honor, but that's
Well,
fine.
Put it on the record. Tell him how I can have contacted the victim. Put it on the record. No, you can't just say that I've contacted the victim and not explore it further. You can't allow me to contact the victim either. So if he just said I contacted the victim, put it on the record.
There's only constitution.
I know I can't contact the victim. He just accused me of contacting the victim, so put it on the record.
Well, let him, if he
He just said it, sir. The whole world can hear him say, actually, he did contact the victim. So now he needs to articulate how I contacted the victim for the record so that the only thing is not on the record is, actually, he did, sir. He needs to articulate his position like a lawyer. He just accused me of contacting the victim, sir. That's a violation, right? If I contact the victim, that'd be a problem, wouldn't it?
Matt, the legal loser.
If who decides to charge me? He doesn't get to decide shit about contacting the victim. He's asking you about me contacting the victim. If I...
I was asking me to tell you not to contact him.
No, he's saying that actually I already did. He just accused me of contacting the victim to twist the narrative. I haven't contacted the narrative, and if he's going to put on the record in your court that I contacted the narrative, I'm demanding he articulate when and where I contacted the victim for future reference on the record. Just like an evidentiary hearing, all that shit. I have the right. You have just like he's asking you to. You need to order him to articulate how I contacted the victim if he's going to make those allegations into this microphone.
You can request to make it, but I don't have to follow your request.
You're saying I can request that you make him articulate it, and you're saying that's something we decide. That's like an objection in the moment or something.
I think
All
it's
right,
Matt doing the
so
crying.
objection on the record.
It's all being recorded, it's on the record.
Oh, it's being broadcast live.
That's fine. Okay, so you're suggesting an evidentiary hearing as opposed to
witness interviews.
Take up the court's time. Take up the court's time because grown-ass men can't have an interview. You fucking arrested me and held me back in the cop car for an hour and a half and said a jury's just 12 people too dumb to get out of jury duty. Don't give me this he's scared shit. I'll go to the police station. Put 50 fucking cops in a room and I'll go interview this cop in a room.
Sir.
It's bullshit. Why are we at day 105?
Let me ask you, Mr. Myers. Do you object an evidentiary hearing as opposed to an interview?
Oh, we're gonna have that too, though. So then I get you're not gonna deny me due process. I get the pretrial. Okay, the only reason I haven't filed the suppressed to get the thing because I'm trying to get my civil lawsuit. I need that deposition because I'm gonna be suing him after. And right now I can use the power of the criminal court. So I let him accuse me. Now I have power. If the judge doesn't go off script and go off the law. So what I'm saying is I have the right to a pretrial interview, okay? I take that interview, then we have an evidentiary hearing. We come to that evidentiary hearing under oath, and then I can ask him questions I already asked him in the pretrial interview, and then ask him it again, and if he changes his story, I can say, I want to perjure the witness, I want to show you this, where in the pretrial interview he said this, and then once he knew all my questions I was going to ask him at the hearing under oath, he changed his answer, okay, because the pretrial, I do this for a living. I have lawsuits in multiple states. You can watch I know you can't, but I have a whole YouTube channel deposing cops. This cop will be deposed by me in a pretrial interview before a hearing. This is my right. I am accused of a crime. I get the full remedy available at my defense. Everything authorized under the Arizona Rules of Criminal Procedure, I'm allowed to enact. I've asked for the cop's interview many times. There's no reason that a armed police officer who claimed to her that he could beat up 46 people and he only came there to beat me up and leave. The arresting officer said to his body cam, to her, he only came there, I was coming here to beat him up and leave. He literally says that, dude. And then he says, well, you're right. The judge is probably going to throw this out, but I get to fuck with you tonight. And then he said, and I said, well, I'm just going to show the jury the body cam. And he said, no, you're not, because the jury's just 12 people too dumb to get out of jury duty.
Okay, Your Honor, can we move on?
No, we can't.
Okay, can we move on, please, Your Honor? Thank you. Okay.
Why does he want to move on?
There's no chance that an interview is going to be productive with Mr. Myers?
No chance.
Police officers?
No chance.
I think it's better to just do an evidentiary.
He thinks that my rights should be violated. I should take away my right of free speech.
Can you please exercise some control here and please stop?
Can you exercise some control and stop lying?
Mr. Myers, sit down.
This judge is doing a great job of handling this. You're the one that's standing here lying and inflaming the situation with every lie.
Mr. Myers?
Every time he lies, I get mad, right? It's pretty obvious. Every time he lies, I get mad. Every time he doesn't lie, I don't get mad. I got it. I'm in control. Oh, trust me, I'm controlling myself.
Okay, yeah.
You know what I'm saying?
If the court wants to order a deposition of the officers under Rule 15.3, that's within the court's prerogative. I think an evidentiary hearing would be best.
Well, I already filed the motion for that, but they won't rule on my motion to produce the officer. I filed it months ago. Okay, I'm following the procedures. I filed the Rule 15 motion because I tried for weeks and months to get the interview. Then I filed the motion to compel the interview. And this man hasn't responded to one of my filings in months. Months. How can we litigate? If I was a defense attorney, the state wouldn't ignore him. The state would, it's because it's me and they know what's gonna happen. Why? If the interview's so bad, it's gonna make me look bad, right? So if giving me a pretrial interview is unproductive, well, the state should want that then because we're gonna have the interview and it's gonna make me look bad. So if I'm the problem with the interview, then let's schedule the interview. And if I go off, if I'm disorderly or you know what I mean? If I violate any rules during the interview, or you get what I'm saying? They just end the interview. The person being interviewed has the right to end the interview if you're not following the rules of the pretrial interviews. So why am I not given a chance to get a pretrial interview, follow the rules of pretrial interview, and then you can decide, you're prejudging me. That's the definition of prejudice. This is a tactical advantage. They don't want me to interview the cop because I'm gonna get to prepare for trial, and then when I got him under oath at trial, I'm gonna get to hit him with all his lies, and then I'm gonna perjure him, but instead they wanna hide the cop till trial. You've been here 25 years. They wanna hide the cop to trial. I smell shit, right? I smell poop. You've been here, bro. You know how the game works.
Okay. I'll go ahead and order a deposition.
Thank you.
When would you need a deadline? I'll say deposition.
Thank you, sir.
Occur by what's the calendar?
In person or what? I want to do it at the police station, in person. They can have 10 cops sitting there. He could come there, and I'm recording it because it's my right, and I'm going to provide him a copy if he doesn't come. I know the problem I'm acting like this is because this started out with me. Sir, do you get what I'm saying? I've already filed everything I'm required to file. We could have trial today, and I've made all my Rule 15 disclosures available. Supplemental disclosure, initial disclosure, witness list, evidence, like electronic evidence. They have a Google Drive with all my evidence, and I have nothing of theirs.
What conditions is the court attaching to the interview? Or the deposition?
Conditions?
What conditions do you think are? I'll ask you first and then I'll ask you, okay? What conditions?
Again, Your Honor, I don't think abusive, profane language, I don't think being able to go in there and accuse the officers of sexual conduct of people in the case is going to be an appropriate topic for a deposition. So what conditions is the court attaching?
It's too hard for me to predict.
Thank you, sir.
I can't, at this point in time.
It's up to me if I.
Until it does something, I can't.
It's kind of like pornography. You know it when you see it. You know what I mean?
So what I'm going to order is that a deposition occur no later than October 11th. Does that work?
Sure.
We only have till November 14th to do trial. So, I mean, you're going to give me a deposition. That's supposed to be enough time for me to prepare my thing. We're going to have an evidentiary hearing. We're going to have a motion, unless we have the motion to dismiss and the evidentiary hearing all in one. And then they still have to give me 20 days ahead. How are we? Okay, so hear me out. You just ordered a deposition of the arresting officer. I still don't have the witness list. How are we going to have an evidentiary hearing or whatever when I can't even prepare for it? I don't even know who to call the evidentiary hearing.
Are there any witnesses other than those disclosed in the police reports?
No. Same as disclosed all witnesses, all police reports.
He has not given me, sir. I'm gonna show you what permission to approach. I want to show you something. Here, sir. Permission to approach. Right here. This is what I'm saying. They haven't given, right? A rule where he can say he did it, but you have to file it like I did. You have to file with the court that you disclosed. He can say all the witnesses have been disclosed. So what he's falling back on now? Well, then how come when he was at the hearing with Mayhew, he spoke into this microphone and said, "We're not sure who are the witnesses. We're gonna."
Luke, I do not have any new information on Tuesday's bond hearing. If bond is reasonable, I don't see why he wouldn't be getting out. So
We're still preparing all that and getting their schedules when the.
Now he said the witnesses are in the police report.
They're all there, Your Honor.
At 105 days in so you're calling every witness in the police report.
You know, the potential.
I gotta grab
Well,
some
there's
more
like
water.
15 people. So is he calling? He needs to articulate on the record.
He can listen to as many witnesses as he wants.
He hasn't listened. No, he has to listen to a motion. Sir, he has to listen in a motion. Not he can't just say so. Speak their name. Put. I need something. Not the police report. I'm too dumb to read the police report and figure out who's the victim. Well, sir, listen. He's saying go by the police report. Well, on the police report, she's listed as a witness. Now he's calling her a victim. So if we go by the police report, then she's a witness, and I need to interview her too. You need to order her deposition too, because if I'm going by the police report and that's their witness list, she's a witness list. If he wants to produce and file a witness list that has her as a victim and other witnesses' name, that's how Rule 15 disclosures work.
You designated a witness?
She's a victim, Your Honor.
A victim? He's designated in the court.
I can produce a witness list by the end of the day, Your Honor. That's no problem.
He can produce a witness list by the end of the day, but not in 105 days. You see what's happening here, sir? I appreciate you, sir. I appreciate you being a man of honor.
All this stuff is on the record.
I appreciate it, sir.
Necessary down the line, you have the record for if an appeal is necessary.
Oh, appeal will be. We already know if you don't dismiss it today, we already know where this is going.
So.
He can. So is that an order? They're going to produce it by the end of today, September 18th, 2024. I'm going to have the state's official witness list produced under Rule 15. That was supposed to be produced by August 9th under court order. They violated the court order. Can you sanction them for violating Judge Cranshaw's order, disclosure order? So if you put it, so look, you said, sir, I want to set some precedent for this thing moving forward because now it's right. So you're saying you just gave them till that day to produce a deposition, right? And if they don't, the burden's on me to file the motion to compel and play games, right? So they haven't followed the rules, right? And I've been requesting officially their witness list, right? Just like the thing. You had to order them to give me the deposition, right? And now here today, he's saying I can have the witness list by the end of the day, right? Well, why couldn't he have it by August 9th? If the witnesses were just the people in the original police report from May 26th, then he should, at some point, he should have said in the record, Your Honor, the witness list is the people in the police report. But he didn't say that till today, 106 days in, now, did he?
I'm gonna do this.
You have these objections and concerns about how he's handling his witness list.
Yep. And that's why I'm going to his neighbors with the Trump sign and asking them if they want to vote for Trump. And that's why I'm calling his wife names, because she works at the school, which is my right. She's a public. If you take your paycheck from the public, then I can call your wife, I can email her. Now I can't talk about the case, which I didn't. I said I asked her if I could come down there and get a special help with.
His wife is irrelevant to this matter.
That's what I thought too.
If any witness other than the victim has issues with them, they have the right to file for an injunction.
So you'll not be modifying the conditions of release, Your Honor, to
At
be
this
clear?
point in time, just
Yeah.
be careful, Mr. Myers.
I know. Hey, trust me. That's my middle name.
Okay.
Walk the line. Lane, walk the line, Myers.
Okay. If any person.
I get it.
Okay,
I haven't been. You notice that it's just baseless accusations. It's not anything that they want to put on the record. Where we just literally had an argument where they're saying I'm contacting the victim. Well, they won't put it on the record.
If those people feel that you're contacting them.
Who's them people? The witnesses? Well, okay, wait, hold on.
What's your name?
Mackenzie.
You want him to contact you?
No, sir.
Okay, so you've been put on notice.
Okay.
You're not to contact him.
Now I'm going to ask you something. Is she allowed to contact me?
You have just no. You don't want her to contact you?
No.
Okay, don't contact contact.
So why isn't she being in trouble for contacting me when the last judge said that we can't contact each other, and then she started posting on my... This woman right here came on my YouTube channel making comments as the victim.
Doesn't she have a First Amendment right like you?
No, because she's contacting the defendant and she's the victim. Wait a second, sir. A First Amendment right to contact the defendant?
Yeah, nothing wrong with that. The laws do not prevent some contact. The way you're...
So I'm not allowed to... The defendant is not allowed to contact the victim.
Correct.
But the victim's allowed to contact the defendant? No, they're not.
Well, read the Arizona Constitution, victims' rights.
The victim has the right to harass the defendant?
You have the right to file an injunction against...
I don't need to file an injunction. I want her to keep doing it so I can use it against her because she's too stupid.
That's your right.
Why would I block her from her own stupidity? She's digging her own grave and the state's grave.
Okay. You're not to contact that witness.
But, okay, wait, hold on now. If you read the police report, we got to get... Okay, you're calling her the victim, right?
Who's the victim?
Right here. That woman has nothing to do with it. That's her babysitter.
So you're not to contact
Her, Mackenzie O'Brien,
You're not
right?
to contact her.
Okay, so let's go over this, sir. When he said he's going to produce the state's witness list, right? The police report lists her as a witness, right? She's the one that called 911. She's the one that was interviewed by the cop. She was the one that accused me of what happened, okay? She's the one that has this alleged video of me breaking the window down, but the state doesn't have it, unless they're hiding it. And so she's claiming that, but so under the same rules of procedure of 15, you can order me an interview with the victim because she's listed on there as a witness, okay? She's the caller. So, okay, you're saying pre-trial. Trial, though.
Trial.
Oh, yeah.
If she testifies,
Evidentiary hearing?
you have
Evidentiary
You
hearing?
have the right to subpoena her as a witness.
Under oath. Right. I don't get to call her and do it or whatever, set one up. But I can bring her, right? Under subpoena. She's my witness, too. You get what I mean? I can put, okay. So save it for that, then you're saying, right? Okay, so here's the thing. The police report, it has all their information blocked out. So how can I set up witness interviews with the information
Never
they've
got
already
the
given me?
deposition.
And now they're saying, well, you had 105 days to contact them. Well, the information's blocked out. So now today, September 18th, they're declaring their Rule 15 witnesses, and then and saying, oh, you've had it on the police report. Well, why, if those were the witnesses the state was calling, why wasn't there information on there so I could set up pretrial interviews? That's how it works. You don't get to put them as a witness because I have another case where all the witnesses, their name, address, telephone number, birth date is listed on there, right? And it's on me to respectfully call them and not harass them, or you get what I'm saying? Legally, hi, I'm contacting you for your interview, you know what I'm saying? That's the bounds of the conversation. Well, then why haven't I had 105 days to set up with their 15...
Today, disclosure list will have that information.
It's going to have their name and contact information, isn't it?
Are
they minors or not?
I'm sorry, Your Honor, what was your question?
Contact information for your...
Yes, of course, Your Honor.
Okay.
Yes, of course. Yes, of course. Why not 105 days ago? Pompous asshole. That's what he is. He's a fucking unethical prosecutor.
What's going to be today is we will set deposition of the arresting officer no later than October 11th. States will make its Rule 15 disclosure today by your business today.
Sure, and just for the record, Your Honor, all disclosure has been made available.
Okay, I understand for the record.
Not the witness list. You have to do it officially, sir. You have to do it with a certificate of service. You have to file it with the court.
It's on the record.
For the record, all mine has too.
Then,
Evidentiary hearing, set one. Because that's what's gonna, naturally after I get this October, you have the inherent power to manage your docket. So what I'm saying is that this is the schedule. He's gonna give me my witness list today. He's gonna produce that I'm sure they're gonna wait till October 11th at the last second, but that's fine. And so then, as soon as I get those interviews, I'm gonna file a motion to suppress, and we're gonna have and I'm gonna ask for oral arguments, evidentiary hearing. So I think in the best interest of this case, for time management, case management, just go ahead and set a evidentiary hearing because in the next 10 days, I'm filing as soon as first I need the interviews, right? To know what the witnesses are gonna say, to know if I need to suppress it or if I need to dismiss the case based on their testimony. I haven't even had the opportunity, and you have to give me at least 20 days before trial to file my motion to dismiss and suppress and all that shit. So I'm the one that, and that prejudice is gonna be argued that I've given all my disclosure months ago. They're waiting till today under court order.
Absolutely game time.
The crazy defendant accused of all these crimes turned over all the exculpatory evidence within fucking 4 days of being arrested. Okay, they've had all my disclosure since the first week of June. We're in the last week of September.
So this event occurred.
May 20th.
Allegedly, okay, May 20th.
And May 26th. So one, I didn't. Okay, so
We'll go by the earlier date.
the day I got arrested for the May 20th on the 26th. You get what I'm saying?
Okay.
So, but it starts from the 20th because that's what he wrote.
Well, Rule 8 is from the arraignment date.
No, it's not. I was arraigned,
Rule
sir.
8 is from the arraignment.
Unless,
That,
sir, unless you're issued the citation and released, which I was, which could constitute my first appearance when the cop issued me the citation and let me leave. And now, if I was taken to jail, it would start from the arraignment.
Mr. Myers, you can file a motion arguing that point.
Okay. Rule 8 is
What
from
I'm
the
saying is, so we want to set a evidentiary hearing.
We can do that.
Please not October 15th. That's my birthday.
We won't do that. That's too soon after the interview.
The state's,
Right, no, I'm going to be celebrating the interview on my birthday, though, that's for sure.
state's available on the 15th, Your Honor.
No, we're not doing it.
See how this dickhead just tried to get that hearing on my birthday just to play? You see what's going on, Rijoas? I got him by the balls, if he even has any. These days, you never know. He might be identifying. I get it.
I'm asking.
He doesn't get to hide from the case, and then when I see him, I feel you, sir. I respect your courtroom. I want a fair trial, and I'm going to respect you.
All right, so we want, so an evidentiary hearing, let's set it. Does October 22nd work? It's a Tuesday morning. Does that work, Mr. Myers?
I've been ready since 5 minutes after I got arrested. I was ready for trial the next day.
Let's check his officer availability.
Yeah, we know he's lying. He's delaying.
Mr. Myers, please.
He said 4 times he had the list, though. I know he's checking. So I got a few. When he's ready to speak, when he gets his excuses ready, I'll stop. But he's had 4 times. 3 other judges have asked him all these questions, sir. And somehow I got yelled at in court and told to sit down, and he didn't get none of these. I appreciate and commend you, sir, for fucking. Because none of the other judges would do it. They said, I don't want to be involved in this because I know what's going on right now.
I'm going to check officer scheduling, Your Honor.
Yeah, go ahead.
Yeah, you bet they're courting, you know what I mean? So how fair is it that the person who's innocent until proven guilty has given all the evidence to the people accusing him, but the state, under law, has the burden of proof to prove? So I could have been sitting here delaying the whole time, right? I could have been uncooperative, and we could have been here talking about how I haven't turned over anything, and you know what? That's how, like lawyers, they set the tone, right? So from the beginning, I turned my shit over. I said, here's my shit, here's, it says I got to turn this in by this day. I might be a defendant, I might talk crazy. Here's, legally though, if I'm going to represent myself, the deadlines apply to me, the court rules, you know what I'm saying? Lane Myers, pro se idiot, has met every deadline, every filing, had every argument articulated with case law from the Supreme Court. My 12-page objection of everything that was going on at the last one where it got stricken from the record because it contained the word bullshit, okay? It also contained a lot of Supreme Court case law from the state of Arizona, okay? In Court of Appeals. So let's see. I've literally said the word bullshit in here, you know, and I'm gonna tell you right now, sir, the next ones aren't gonna go like this. Because I had to put my foot down, and you did too. And now?
October 22nd is a good day for an evidentiary hearing, Your Honor.
Are you available October 22nd?
I'm available any day that ends in Y, other than October 15th.
Okay, October 22nd at 9 o'clock, we're doing evidentiary.
Here.
In this court.
Is it that or that, like, is it?
I don't know.
Okay. Oh, that was something not out of your control?
Yeah,
Right.
it was an equipment issue.
I thought they just put me in here so they could. I'm just fucking with you.
It was originally scheduled 14, but there was equipment issue, the recording system wasn't working.
So your normal is 14.
I know, I'm a retired judge, I don't have a normal call.
Oh, dude, hey, you're retired, so at least this one ain't gonna be boring. You're gonna get to put all them years to use. Because I'm telling you, sir, I promise you, I'll just let my argument speak from now on.
That's fine. So you have an evidentiary hearing, October 22nd at 9. So there's 3 things I'm gonna order today. 1, witness list, state's witness list disclosed by close of business today. The deposition of the arresting officer no later than October 11th, and evidentiary hearing on October 22nd.
Can I give you the motion?
What motion?
the objection motion that got stricken for,
Bunch of motions in the file.
that's what I'm saying. So how does this work, right, sir? So I filed the motion, Claude's transferred it, right? I filed the motion and it was assigned to Mayhew. She came to court and said, I'm not accepting the motion because it has the word bullshit. Well, my motion was timely.
All that stuff's in
and
the description.
She's not the judge anymore. So why isn't my motion gonna be ruled on for the Rule 8? Or the objections? Let's see, I'm pretty sure I gave it to you right here, sir. Permission to approach, right here. This is the one that she struck from the record, sir. It uses a lot of languages that you don't want to hear as a judge, like, hey, I'm going to file a judicial commission. But the judges have the right to public scrutiny under the canons. And that's what happened. She did that to me, and I sent her judicial commission complaint by email, and then she got off the case as fast as she could within 3 days. Mayhew was on the case for 3 days because she struck that thing. She couldn't give me what rule of evidence or what rule of procedure or what law says you can't use the. I have federal motions that say way worse stuff in federal court where I have Monell civil lawsuits against many people. So for her to come in here and say, and then when I pressed her on, hey, okay, what motion is being stricken? Oh, all motions, some motions, just that motion. Okay, under what rule of procedure are you striking the motion? She cut me off and cut me off the Zoom because she didn't want to answer. So then when I emailed her and said, tell me under what rule you're striking my motion for the word bullshit, she recused herself from the case. So my objection, you just sat here and said you can file your objections. I have folders of objections, sir. The files are full of objections. Every single order that this court makes that I don't agree with, I file an objection immediately.
That's your right.
And it's all going to be on the appeal record, you know what I'm saying? But she struck it from the record because that would have to show that Judge Klotz, see how, sir, I'm not saying you were led to believe, I'm not that great with those kind of words, but like you were under the impression that I filed the motion to continue because that's what somehow got on the record by Cranshaw. And even as the state just acknowledged, I never filed. So the whole continuing thing and blaming it on me started this whole process of me not being an opportunity to be heard, not being able to have my motions heard, nothing. My motions were stricken for the word bullshit, but there was other motions than just that. And so you get all my disclosure, my motion to compel, I filed a motion to compel this deposition months ago.
Okay, so here's what we're gonna do. On the October 20th.
Right. Let's make it a motion hearing too or whatever. So you want me to have all my motions as dismissed, everything in by then is what you're saying. All right.
You got at least 10 days beforehand, so.
10 days before the hearing? What is?
His recommendation.
No, I don't understand. So what?
It's fine, Your Honor, we'll have our response timely.
I'm sure they already got it ready. Because remember now, you do know they amended the complaint, right? And I objected to that.
I saw.
So how come I wasn't allowed to? All right, when the amended complaint, let's look at that for a second because I'm getting all my arguments off today because you're giving me a fair trial and you're retired, so that means you got time. And so, I actually, where's it at?
Motion to correct citation.
It was an amendment. You got that thing right there? They gave it to me. Wait, it might be in my bag. Where is it? They gave it to me they waited till the end of the hearing and I was walking out of court at the first hearing to tell me they amended the charges. Well then, if they amended the charges, the case should be dismissed because the officer said that he was arresting me specifically based on the contents of my speech, 1329.043, but then after I turned over my disclosure and showed him the evidence I was gonna use to fight that charge, they amended the charge at the first hearing. Sir, do you have a copy? Right here. The state's motion to amend, you have that?
Yeah.
Okay, so you see, even in the case law, a complaint may have been amended to correct mistakes of fact or remedy formal or technical defects. So
We're going to hear about the formal defect in a second. But I just wanted to I guess highlight Game Tech Reserve. I don't like that he's in jail either. And can we try to discourage him? It's unlikely. You know what I mean? Depending on how long you've been around, you know what's going on. So, and I'm not saying Game Tech Reserve doesn't know what's going on. I understand what you're saying because he's in jail. Like, that's the point, right? Like, maybe don't make the silent video. Go ahead and blame me for the rest, right? That was me. I did that. I said this in the last couple live streams, but we saw the initial disclosure from the current 14 charges. This isn't even counting the 3 new ones. Where was I going with that, guys? Oh, the picture, right? So we were looking through the discovery, right? And in one of the police reports, the officer states in the police report that Lane Myers is Shannon Walker's ex. So, this shit's ridiculous as it is, right? I mean, come on. This shit is just so ridiculous. So, I've got a certain kind of, sense of humor. It's not for everybody. I admit that. But I enjoy my sense of humor, and, my close friends, they also, they enjoy my sense of humor as well. So I made that because she was accusing him. What she's saying is so outrageous that, I just tried to make light of it because, what else are you going to do? Where is it? So outrageous. Where the heck did it go? Oh no, you didn't go far, did you? There it is. So I thought it would be funny, you know what I mean? I made a joke and I sent it to Lane. Come on. Come on. Come on. It's a joke. It's a funny joke. Seriously? You're gonna tell me that... Come on. So, yeah, that's what's happening. Oh, the ornaments, yeah. That's actually not the original picture. It's had several iterations. But I started changing the bulbs on the Christmas tree to Lane's head. So it will evolve more until it reaches, an even more ridiculous level, unless I end up in the gulag as well for felony meme making.
What was the mistake of fact or formal or technical defect? And I objected to that, but he kicked me out of court because he waited till the very last second, handed it to me. I wanted to object. What are the mistakes of fact or remedy of formal or technical defects? Because all the states, if they say I have all the disclosure, then their disclosure says, but in the police report, the cop's words were.
Yeah, I'm sorry if I didn't make that clear. JC's right. This is all enhanced because of that statement that she is his ex, or that he is her ex, or whatever the fuck. It's in, Matt Walker knows that. You know what I mean? And he's sharing his work product with the Pima County prosecutor anyway. So, he's already colluding and retaliating. So he
was arresting me for saying what I said. We won't talk about it till trial, but He said, you're being arrested for what you said, and I'm
Thank you,
going to come to
Seven
court
Cities.
and play the
Sincerely.
video of what you said, and that gives me probable cause to put you in handcuffs right now for what you said. I wasn't accused of how I said it. So it's either what I said, okay, under 1329.004 disorderly. If you use 3, that means speech in the state. So originally they were arguing that it was 1329.04 for my speech, but when I gave them the case law that says they can't use 1329.043 unless it was fighting words, and I showed them the case in R.E. Louise and State versus Brahe and all these cases, they quickly and last secondly amended it. But what mistakes of fact or technical defects would there be that would need them to go from, no, we pulled you over, we are investigating you, we're arresting you for what you said. So what technical defect did they discover that took this, me being arrested from? Well, we're not arresting you for what or how you said it. We're arresting you for what you said. And I said, well, it wasn't fighting words. And they said, okay, well, we'll just amend the complaint to whatever to keep this case going. And I should have been argued that it says a complaint may be amended. Just because you motion to amend doesn't need to automatically.
Yeah, so that's an interesting question, right? So I saw a couple different comments. The one that Surf said, I commend him as well, right? Many people will say, oh, he's so dumb, that's so stupid, Lane's an idiot. But what he did actually takes a tremendous amount of courage. And I know that that's lost on a certain type of people, but that is the fact. And then there was a comment after that yes, so the pick was good. It was good. And then hindsight. So the question is, if knowing what I know now, would I do it again? Right? Knowing the consequences. And I have to be honest with myself and dissect that a little bit. So we'll take away the first charge there, which was the silent movie that of Lane searching for Google search results. Okay, so that one's on Lane. All right, so let's say that he didn't do that. Then it just comes down to he came on to the show and got interviewed. Well, if I say I wouldn't make the picture again, then I'd also say that I wouldn't interview him about the charges. You know, he came on to talk about these 14 new bullshit charges. So, you know, what am I doing if I wouldn't do that again? You know, if I wouldn't have the conversation with him about that stuff, because you know, that's the whole point, is to get more exposure on it. And you know, we need a lot more than the exposure that I'm adding to it. And I appreciate the people that have been helping me work on this. And all the people that have sent the calls and the emails. That means a lot to me, and it means a lot to Lane too. So, or I imagine it will, or you know what I'm saying. I'm not sure if I had somewhere to go with that thought, but we gotta
Automatically be it's granted, and that's what Cranshaw did. He just stamped it right through at the last second. He did not allow me to object. He did not require to put their what is the mistake of fact or formal.
Thank you for having me on the
defect
show again,
that led them
Dr.
to motion this and have it granted. You're gonna ultimately, the appeal is gonna show that this was granted without any finding of correct mistake of fact or remedy formal or technical defects. Tell him right now. I'm requesting you to ask him what led to this. to tell us the mistake of fact or formal or technical defect that allowed them to amend it.
On 20 seconds, you can raise that issue.
Thank you. So you want me to, it's not gonna be one of those 5-minute hearings. I can bring like case law and like, thank you, sir. I just want my opportunity to be heard. I don't want to come in here and say F this, F that. I want to come in here and say, state this, case law this, law that. And that's what I've always wanted. And I told him from the beginning, if you act like a ethical prosecutor, I'll act like a polite professional litigator. But he's in here crying about, I put it on the YouTube. I got it from a public record. He's saying, he's contacting public officials. Stop it. You're hurting their feelings. You're hurting their feelings. They're public officials, sir. Just like, you have under the canons of Commission of Arizona Judicial Conduct, one of the first canons is you have to, you're a public
All it
official.
takes is finding
you have
that
to accept
the right
a higher
person.
level of
One
scrutiny
person is
than
all
the,
it takes.
than the normal person. It says that literally in the law. Thank you. Huh? Yeah, it's in there, right? So that's the one that she claimed bullshit or whatever, so she was gonna strict it or whatever, I called the officer Deloria Dumbfuck or something, and she didn't like it. So then I can't have my motions to her that contain, literally, you see, it's 12 pages of case law, and if this was a defense attorney that filed this case would have already been over. But you just got it today, and I could see that you're gonna enforce the law, so.
All right.
So Matt's gonna go home and cry to his wife now about how I.
I can't hear you because Mr. Myers is on.
Oh, I thought it was still my turn.
Anything else? All right, three things on this today. Witness list, deposition, and the evidentiary hearing. Evidentiary and motion.
What time on that 22nd?
9 a.m.
9 a.m. All right.
If you guys see videos,
What's
send
the
them to
process,
me.
sir,
I'd appreciate it.
for getting my people? So,
please.
so if I want to put physical evidence in at the motion here, at the evidentiary hearing, I want to request her to turn over her cell phone, stuff like that, get all my subpoenas in and stuff, because we're going to get her phone analyzed because she only gave 17 seconds of a 9-minute conversation. So, context, exculpatory evidence. The state has an obligation to find evidence that will not just find me guilty, but which will also find me you know what I'm saying, sir? The state has to not only show evidence that.
Yeah, his lawyer wanted him to take the videos down, but, his lawyer's doing lawyer stuff. And I think the lawyer's first job is keep Lane's ass out of jail, right? So, I don't blame him for that. I think that, he volunteered to go on the next case. I think he's zealously advocating for his client, and I think he was up until the point that he he withdrew from the case when Lane won his motion to go pro se. So, there's two lawyers in the Tucson area that I think have integrity. Every other lawyer that we've run up against, it seems terrifying. The way that they behave.
Makes me guilty. If they have in their possession or knowledge of evidence that would show my innocence, they also need to produce that. And they knowingly have evidence that will show my innocence, and they haven't produced it.
Yes, any channel, any videos, so I can share them too.
And Your Honor, the only reason I know that they have a 5-minute video of what actually happened is because I did a record request and got the body cam of the officer that went and talked to her, and we could see we can literally listen to her. So, sir, can you give me a second of your attention? In the video with the police, she says, I have a video of what he said at O'Reilly's. She sets it on the table, and it goes for 7.5 minutes. They turned in a 17-second clip of that video, and if I didn't have this body cam, I wouldn't even have known that she had a 7-minute video of the whole thing, but they're only turning over 17 seconds of it, because if you turn over all 7 minutes, it will show what actually happened, not their little
Also
edited
true,
version. That's
Spencer.
like me going and taking one thing you said today and putting it on my YouTube channel, and it defines this whole hearing. That wouldn't be fair to you either. If there's 7 minutes of you speaking and I clip out 17 seconds and accuse you of something based on that and don't provide the full context, that's a violation of the same rules of disclosure of the exculpatory evidence and all that. So this guy's talking in circles. I told him I was going to beat him if he didn't drop the charges. They're trying every trick in the book. The law stands on my side. The evidence, the procedures, everything that's happened in this case is in my favor. Except except when I came to court before today. And Your Honor, you deserve that title, Your Honor, because you actually have some. Now Matt's gonna, hey sir, I'm pretty sure that they'll dismiss the case in the next few days once they realize now that I'm gonna get that deposition.
Instead, Matt goes
And
insane.
put it all over my YouTube channel and show the whole world this lying cop. Just like I showed the whole world the lying victim witness slash protagonist. Somehow she's the victim and the protagonist. She just said, on the record, sir, you just heard her. This is a game. This is a game, sir. You literally just heard the victim say, when I said she was the victim and the protagonist, she said, because she works with the Tucson police as an undercover cop. She admits it in the video. You'll see. She said she's a confidential informant for the meetups of the car meets, and we'll get into the rest of it later because it's none of these other people's business. She does admit that her mom is in a relationship with a Tucson police officer on the video.
Your Honor.
That's irrelevant.
I get it, okay.
Go ahead and sign it. Okay. Can you type it?
I heard you say October 22nd.
Oh, it's legal and evidentiary. One second.
I just want to be clear in case anybody missed it. We heard the prosecutor just ask Judge Riojas, please make him stop making videos about my wife, calling my wife, emailing my wife. He said those three things, and the judge ignored all of it because she's a state actor.
So subpoenas for the, right, so here's the thing. I don't have to fill you up with a bunch of paperwork. Are you calling her at the evidentiary hearing?
He doesn't have to tell you.
So he could just show up with or without her? Right, so I need to put a subpoena in so I can subpoena the quote unquote victim, playing the victim, fake victim, whatever you want to call it. They could file an objection to me wanting her at the evidentiary hearing? Okay, and so what about, so is the arresting officer required by statute or anything to be at the hearing? Who's required from their side to be there?
No one's required to be there, but the problem is, if they don't have witnesses, they can't counter.
Right, so if they show up with nobody, then there's really nobody to,
Exactly.
okay, and so they're not required to disclose who they're gonna show up with, is what you're saying? And
Doesn't show up, can't testify, anything there.
right, and so if I want anybody to be there, I need to start, you're saying the form's downstairs, subpoena production of a person or evidence, right? For October 22nd, I turn them in, like I file those like a motion? Okay.
I mean, we'll tell you this, well, no. Okay, then, we going, I can't, usually I can type it in, because the computer's not cooperating. Okay, but,
And you ain't gonna get no money from me to buy a new one either.
actually, the Supreme Court.
Hey, the mayor and council,
No, these are
they're,
not. Okay, state disclosure, used by reduced.
they're your boss. We know. We know that I'm suing the council for booing at the meeting, and this is what this is all about. This is Matt Walker's last chance to save the city of Tucson and his job.
Deposition of arresting officer, for no later than October.
Deloria, his name is D. Deloria.
Did I say arresting officer?
Can you please put the D. Deloria so they don't try to, because there was 3 cops there, but I want the name, I want the off right here, so the name on the ticket, permission to approach. It's right there, sir.
Okay, I got it.
Yep, thank you. Badge number 48098.
How do you spell it?
Deloria. Badge number 48098.
All right. And,
Sir, have you been in any ex parte communication with the state?
I haven't seen him in 6 months.
Thank you.
All matters
You probably won't see him another 6 months after this hearing when he goes and hides.
my
He wants to take public tax money, but not face public scrutiny. That's called the opposite of a public servant. That's a thief of taxpayer dollars. That's a controlling, let's control you with the law. Let's take our money from the very same people we took an oath to protect and serve, and let's do anything. Hey, Your Honor, would this be, can we deal with this now? All right, so Matt Walker, the state.
Lane has a bond hearing on Tuesday the 25th and a court date to modify conditions of release on the 28th.
He has a 56-minute presentation for the prosecuting
Yeah, can we move on?
attorneys union where
Move on.
I'm gonna, and this might be admissible evidence.
Let him finish, see what he's got to say.
Okay, so on the so in my research, so Matt Walker, the state, he has a podcast for continuing education that's listed on the Union of Prosecuting Attorneys or something.
APAC.
And what is it, CPAP or
APAC.
Right, okay. Where in that 56-minute presentation, he gives a presentation on how prosecutors can weaponize the disclosure system to protect the state from unlawful, like if they unlawfully arrest somebody. This man gives a 56-minute video on the internet of how to manipulate the disclosure system. It's called Disclosure from a Shield to a Sword, right? So this man has a 56-minute video explaining how to go against, like, not let the defendant to use disclosure. It's called, you know what I'm saying, making the case stale. My wife, until a few days ago, it doesn't matter. Anyways, so just like his wife, it's the same thing, right? I guess our wives are part of this case now. And so, public employees. But anyways, and this I believe is relevant. Because if we take the facts of this case and we can see the pattern of disclosure going on in this case where I've turned over mine, and then this man has a 56-minute presentation for other state attorneys saying, this is how you manipulate defendants' rights. This is how you protect the state from getting caught manipulating the defendant's disclosure. It's called turning it from a shield, because normally the state has the burden of proof.
I'm gonna put that on Lane's commissary so he can get some socks
to present their evidence in an ethical way. This man, Matt Walker, has a whole video for the state how to be unethical with disclosure. And it's disseminated for money on the internet, and you could get credits for your continuing education on a video. And if you take the video, sir, it's exactly what's going on here.
Thank you very
They're
much
manipulating
for
the
telling
evidence. They're
anybody
hiding the
who would
arresting
listen
officer.
sincerely.
They're failing to disclose until a court order. This man is an embarrassment, and I already knew all this was going to come out. So it's a pattern. This man makes a video for the whole world to say, I'm Matt Walker, and this is how you screw defendants over using disclosure. A sword. He's using disclosure as a sword, sir.
Well, sir, the remedy to that is for you to file.
And I've been filing them. I've been filing them.
And then for you to present your
Yep.
evidence, and it's up to the court
Yep.
to decide.
I get it.
What, if any, sanctions are.
I know. I did. And sir, Your Honor, I haven't done the sanctions one yet because you can't do this. You can't skip. First, you got to do a motion to compel. You order them. If they don't follow it, then I can do sanctions. But I can't just go from asking for an interview to sanctions. I had to file the motion to compel. It wasn't ruled on. So if the motion to compel would have been ruled on,
Lane talked
then
himself
I
out of those
could've filed the motion.
handcuffs
You get what I'm
too.
saying? If the motion to compel, you can't skip the motion to compel. You can't go from nothing to sanctions. I have to file the motion. You have to give them a chance to be ordered to do it. And then if they don't follow your order, then I can ask for sanctions. Do you get what I'm saying? But I couldn't do that because nobody would rule on my motion to compel. And now, you get what I'm saying? And now you just did today. Thank you. So moving forward, if he does it on the 11th, he's getting that sanction, 15th, right, exactly.
You have the right to request, yes. Can you come and sign up the order?
Yeah, no problem. Permission to approach?
Sure.
Yeah, fill out the
We need to
sponsor.
make sure it's clear to you.
Thank you. I'll read this.
Okay, you can fill out the whole box. So
Yeah.
whatever, you can put your email, address.
I'd give anything to see
Where-
Matt's
where do you want
face
me to go?
as all this is
What
unfolding.
address you got? Because it's kind of confusing how many
Whatever address you use.
They're just ignoring him. He's irrelevant.
Yeah, because you guys were sending to Michigan, because you know I'm a snowboarder.
What up,
so, like,
Special
I got a
K?
house-
We'll use the address that's on your motion.
We'll just-
4583.
We'll use that, yeah. This is your copy, that's yours.
Thank you.
That's it.
This is the hearing
He's on the 22nd.
here, but the
And
thing.
these are the judge's orders right here.
Right, okay. And the thing, the 11th thing, how does that work? Here, I'll back up. Here's your pen. How does that thing on the 11th work? Is this something like walking out of here, we're supposed to act like men and get a hold of each other and set this up? Or is this something where I got a piece of paper where I got to go down there and bang on the window and say, give me my interview?
You gotta try to make it right for Mr. Walker.
All right.
For sure, Michael.
All right, okay. So I want to state for the record now, I've sent 47 unanswered emails to Matthew Walker.
Now there's a court order, so it notches it up. Okay?
I appreciate it, sir.
That's it.
Thank you. Dismissed.
All right.
That's what's about to happen next. Good luck, Matt. You're gonna need it, buddy, and you too. But I can't talk to you, but you can talk to me.
You can hear it
And that's how
laughing.
it's done, folks.
That was epic. And now you know why Matt's so upset, right? And now you know why all this stuff's happening. You heard another judge in there completely dismiss out of hand the nonsense that Matt was asking for. Oh, please protect my wife. No emails, no phone calls, no YouTube videos. But luckily, Lane didn't let the judge lap that bullshit up, right? So I think this is so important that we might go over it again tomorrow. I don't know. So feel free to tune out, I guess, if that happens, but I think it's important, you know, because everything that this case kind of hinges on is right there in him taking Matt down in open court. So I guess we'll find out if me playing this video is also a violation of the injunction. After all, the C word was thrown around a couple times. You know what I mean? So I appreciate everybody coming in here tonight. I'm gonna go to sleep because it's 2 in the morning. I really appreciate everybody coming in. For sure. Imagine if there was video with that Michael. I mean, you know, I've got the Dabbler hearing, the video of that up on my channel, and that, I mean, my channel is not really that big, but it's already one of like the best performing videos. Court video is compelling video. I mean, I think that's where much more of my focus is going to be, is on the courts. I think that's where the real problems are. So I appreciate hey, I'd appreciate if you wouldn't lick your paw. Don't. I appreciate everybody coming in tonight, and we got to make some phone calls tomorrow. We got to make a lot of phone calls tomorrow. I've got the number and the email pin there in the pinned comment here, and then in the description there's a link to the anti-slap motion. Share that around. share it around. It's an excellent. It was written. It's a great document. So share it around. Maybe it'll end up in the right hands, and the Honorable Douglas Metcalf will do the honorable thing and get him out of the cage. The nonchalance about a man's freedom is chilling to me. So, I appreciate everybody coming in. I hope you have a good night, and we'll see you later on this morning, I guess. This is a public service.